Alright everyone, it's time to talk about gun rights because it looks like the Supreme Court may finally take up a case against New York City in regards to arms transfer. See, what happened is that some time ago, New York City, which is a seat of iniquity, so to speak, if you were a Christian you could call it anyway, likes to try to go after gun owners. They want people to be disarmed so that they can, tax them more and then justify having like really strong armed police tactics instead of letting people sort things out themselves, which would actually drive the crime rate down. Anyway, they passed a law which was blatantly unconstitutional, which prevented owners of firearms in New York City who were lawfully registered under New York law from transferring those weapons, like transporting them out of the city, in order to try to disarm people. What ended up happening is, of course, they were told under federal law that wasn't actually acceptable. A municipality is not allowed to violate the Second Amendment rights of a citizen. You have a law-abiding citizen owning a lawful weapon. They have to be able to take that law-abiding, lawful weapon wherever they go. They have to be able to transport it. To try to prevent them from transporting it is a circumvention of the Second Amendment, clearly unconstitutional. They backed off of enforcing this. They said, okay, we're going to have like gun amnesty, essentially. Therefore, what their argument is SCOTUS can't take up the case because there's no legitimate plaintiff. That is, that nobody's rights are being violated. They passed the law. People's rights were violated. There's the fact that the state says, okay, well, we're not actually going to enforce this law because it's unenforceable. Yeah, we recognize it. Sorry. Too little, too late. SCOTUS may take up the case anyway. Now, is this a little bit activistic? Almost, kind of, sort of. I think it's acceptable. I think it's acceptable for SCOTUS to be a little bit activistic when it expands personal liberty, when it enforces existing constitutional content, the Second Amendment, the right to free expression under the First, the right to privacy under the Fourth, something like states' rights, state supremacy over certain issues. I'm normally troubled by that, and here's the problem. It's like with gay marriage. The Supreme Court normally is and should be reluctant to take up cases. With gay marriage, they could have jumped in as soon as there was a plaintiff back in the mid-2000s and said, the federal government doesn't have the right to prevent law-abiding adult citizens from enjoining in a property contract under the title of marriage. It has nothing to do with God, it has nothing to do with the church, it's just a state contract. They could have done that. It would have caused mass chaos. There would have been like prayer vigils out in front of the White House for years and years at a time. People would have thought Sodom and Gomorrah had come. Instead, the Supreme Court wisely stood aside and said, look, we're going to let state legislatures and lower judges determine this. We're going to let them do that. Because if we get involved and it becomes a national debate as opposed to being fought out on a state-to-state level, we can't really determine the direction it's even going to go in necessarily. We will let largely people have the latitude to do that for themselves. And of course, fast forward a decade, half the states have gay marriage, and a lot more have, reciprocal contracts for states that do issue, or they have civil unions or whatever, and the Supreme Court says, okay, we've obviously gone past this issue, it's been decided for us. Now we just have to weigh in and make it fully legitimate on the federal level. DOMA went the way of the dinosaur. You've had this happen before. The SCOTUS is reluctant to take up cases involving firearms. Which is good, by the way. If the court were stacked with liberal justices, would the people on the right cheering it on for its activism now be so happy about it? I don't think so. If Ginsburg were the moderate on the court, I don't think they would want SCOTUS to touch the case. The fact is, though, that you've got a swing justice. 8 of the justices, we know how they're going to rule. We know that the conservative and liberal justices are respectively going to rule against and for New York City. The real one, the keystone of the court is Justice Roberts, the Chief Justice. He's a Bush appointee. He leans left on certain issues, right on others. We've seen it. He worked himself in circles like a fucking pretzel in order to justify allowing the ACA, even though clearly he should have ruled otherwise. He should have found it unconstitutional. The idea that it was ever presented to the public as a tax, which is how it got passed, is asinine. He did that in order to not rock the boat too much with the executive branch, I suppose. I think it was a mistake. And by the way, the Fifth Circuit, I believe in Texas, is currently considering the possibility that because the mandate is gone, as soon as the mandate's gone, as of tax time this next year, it might nullify the entire ACA. Good, by the way, I hope it does. I hope it becomes fully unenforceable from A to Z. You can replace it with a 2-page bill for pre-existing conditions and expanded coverage and leave it at that. Everything else didn't need to be said. Hey, let's drive up the premiums. Let's drive up the deductibles. It won't cause any problems. You know, the average person will be paying for 10 years before they can get any coverage under the plans issued from the government, but, you know, that's okay. By the way, Vermonters slightly sheltered from this because the state exchange is governed independently and differently from the federal one. It's very interesting. It's arguably a little bit more socialistic, but kind of sort of works a little bit better. Obamacare, so bad, communism is better. And put it that way. There's your slogan for your re-election bid for Joe Biden, term 3 of Obama. I hope that the court takes the case up. I hope that they rule in favor of gun rights. The idea that a state or municipality can prevent a gun owner they've broken no law, they are moving or something, they wish to take their firearm with them, it is lawfully registered, it's not illegal under any federal law. The idea that they shouldn't be able to do that, or that it should technically be illegal but not enforced, which is the current status quo in New York, the idea that that's even remotely acceptable under the auspices of the Second or the Fourth Amendment, by the way, is clearly wrong. It's fairly clear it should be a 9-0 decision. The fact that somebody like Ginsburg would even be capable with a straight face of ruling in favor of the anti-gunners in New York City, the idea that a municipality is allowed to prevent a law-abiding gun owner, the Second Amendment aside, from transporting that weapon anywhere, is crazy. It's a blatant violation of the Second. By that token, you could prevent arms manufacturers in one state from shipping their items to another state. I would think that this would cause potentially a snowballed issue that would lead to a major case. It could lead to a case 10 times more vicious than this one in SCOTUS down the road. So I think that they should probably err on the side of individual liberty on this one. The idea that it solves any problem as well. The Supreme Court is not technically supposed to look at pragmatism. It's supposed to look at clearly what's constitutional, what is or is not allowed within legislation and behavior. But they take in mind pragmatism. They'll neglect to hear a case if they think that it's going to be too much chaos resulting from it. They will rule in favor of what is pragmatic sometimes, or at least consider what is pragmatic with regards to their decisions. That's why largely federal court rulings, which are blatantly wrong, but they've been allowed to stand by SCOTUS, allowing things like the NFA have stood. SCOTUS won't take up any case against it. So you've got this situation where people's constitutional rights are routinely being violated. In fact, every single day, everyone's rights are violated by the fact that they can't mail order a Tommy gun, technically speaking. But SCOTUS won't take the case up, so the lower court rulings that are themselves totally unacceptable, of course, have stood the passage of time simply because they've never been successfully challenged. SCOTUS has latitude to determine which cases it does or does not want to hear. I would say there's a silver lining for all of you people who enjoy firearms in the U.S. if Trump wins a second term. The fact is Ginsburg's going to croak in the next 4 years almost certainly. It's possible that an additional liberal justice might kick off. He can reshape the court and potentially SCOTUS in that new form would be willing to take up those cases, in which case the NFA is gone. Citizens will finally be able to fully exercise their Second Amendment rights, lower court decisions that have always been unlawful. It'll be just like Cruikshank. Cruikshank was found lawful in the mid-1800s. In the 1870s, nobody had a problem with the argument that the Second Amendment pertained to state power, it didn't pertain to citizen firearms, and that everything was shall issue. Nobody had a problem with that because you've got to look at it at the time. You've got burgeoning authoritarianism. You're headed on towards the Gilded Age. Things are getting much more tyrannical, much more corrupt. You've got carpetbaggers entering the government, a bunch of unionists that are just, sort of making their way in because they knew someone in the Civil War, of all things. The South has been stripped partially of representation. There's a lot of animus there, and the Klan has said, hey, we don't want all of these black people who have become citizens to be armed. And so Cruikshank happens. And it stood the test of time because no challenge was taken up by SCOTUS until the 2000s. Over a century of time passed before the Second Amendment was, in that fact, restored. Now, of course, we understand the Second Amendment explicitly, objectively, inarguably refers to citizen firearms, and specifically, by the way, to military armaments. Yes, the Second Amendment fundamentally protects your right to own a bazooka. Is this recognized by federal law? No, because lower courts have stopped that from happening, and SCOTUS, out of a sense of pragmatism, has not taken up a case against them. It's still unconstitutional, but it's just not recognized. This is one of those little gray areas within the U.S. government, within the U.S. Constitution. Something can violate the Constitution for a very long time as long as the judiciary is unwilling to challenge it. If the judiciary challenges it, of course, then things can change. So I hope that SCOTUS takes this up. I hope this is a bellwether that over the next 4 years, I hope Trump gets a second term, stacks the court with people who respect the Second Amendment, and we no longer have to fight over these pieces of bullshit. I should be able to own a fully functioning automatic Tommy gun. Yeah, I should be able to strafe animals in my garden with a Tommy gun. Absolutely. Who should be able to stop me? The state? The state staffed with the same corrupt people from the general population not to be trusted with the same Tommy gun? I always found that an interesting argument by the far left. Yes, I should be able to own grenades. Absolutely. Of course I should be able to do these. I should be able to manufacture these things myself. If I blow my hands off, who cares? It's just the way things are. Ted Nugent would be happy. I consider Ted Nugent a liberal on firearms. That's about all. Peace out.